Hi, good evening, and welcome to today's webinar, When Your College Student is Accused. Now, what should parents do or don't do first? Thank you for coming, and we're going to get started. Today, first, I would like to introduce myself. My name is Dr. Amanda Stewart. I serve as the Director of Student Defense here at K Altman Law. I would love for my colleagues to introduce themselves, and thank you for being here this evening with me. Attorney Garcia.
My name is Attorney Monica Garcia. I am the Student Defense Attorney here at K Altman Law.
Hello, everyone. My name is Mindi Miller, and I am one of the Student Defense Advisors here at K Altman Law.
And I'm Rob Wright. I am the Assistant Director of Student Defense here at KAL.
Well, thank you so much for introducing yourselves. Here, from this, you can see here at K Altman Law, we are a multidisciplinary team. We are made up of attorneys, advisors, educators, former professors, school administrators. We have the experience and we're ready every day to support students and families through academic integrity issues, conduct issues, and Title IX issues. Now, for today's presentation, we have a few objectives that we would like to reach. First, we want to make sure that our participants can learn about the types of allegations within higher education, understand why timing and sometimes silence really matters, and know what support is available and when legal advocacy may be needed. We also talk about and we will share about avoiding the common parent lead mistakes that can worsen outcomes based on our experience. Now, our goal is to give you a roadmap so you can respond strategically, not reactionary. Let's get started. To our next, all right, Mindi.
Yeah, thank you. So as Dr. Stewart mentioned, allegations and stakes are high in schools. We want to talk to you about common allegations. They fall into some basic categories. There's academic dishonesty, student conduct violations, and Title IX concerns. Each of those have their own processes, and each of those have their own sets of consequences. But consequences can be extreme. Potential consequences can lead to suspension or even expulsion from the school. Sometimes minor consequences include transcript notations, but those transcript notations can have long-lasting effects in that they stay in your transcript for a very long time and can follow you from one school to the next. Why does timing matter? Early mishaps can cause problems. Silence sometimes protects the way you can say those statements. And situations can also turn difficult when you say the wrong thing at the wrong time.
That is
and we'll turn it to Rob.
Thank you. Getting back to what Mindi just mentioned about types of allegations, most of the issues kids confront fall into three broad categories. Different schools call them slightly different things, but basically there's academic dishonesty or academic misconduct violations. Then there's student or disciplinary or behavioral misconduct violations. And lastly, Title IX violations. To go a little bit more in depth about the different kinds. With the first type, academic dishonesty and misconduct, there are two main types of that. And usually what we're dealing with is what's referred to as plagiarism and cheating. Now, of course, there can be overlaps between those two things, but regardless, either or both are considered to be violations. And something that's important to know that a lot of people don't realize is that plagiarism today is used as kind of a blanket term by schools. It certainly means, in general, submitting work that is not your own. And I think that's the kind of plagiarism most people are traditionally familiar with. Or paying someone to complete coursework for you or to take an exam for you. But what is broadly called plagiarism in the school violation world also includes things like using prohibited notes or resources, on an assignment or during an exam, collaborating on assignments that were supposed to be completed individually. And that can also mean something that's called self-plagiarism, which is kind of a new concept. And basically that means double dipping or recycling an assignment, for instance, that you did for one class and using it for another, or a previous assignment using it for a later assignment. That doesn't fit into the traditional notion of what plagiarism is, because it is your created content, but that's something that many schools nowadays, many colleges and graduate schools still prohibit, and falls under that general rubric kind of self-plagiarism, plagiarism. And then sometimes citing sources improperly can be considered plagiarism. So even if you've made some kind of an attempt and you are in fact attributing what you've done to the proper source, if you don't do it correctly or in the right format, graduate schools and postgraduate professional programs in particular, like medical schools and law schools, can be extremely picky about the notion of citation formality. Secondly, we have student conduct violations. These are things that aren't related to academics, but they're behaviors and actions that are generally prohibited by the school's rules, and they largely mirror things that aren't allowed in most public settings. Alcohol or drug violations. Campuses, as well as college campuses, as well as K-12 schools, have strict rules about this now. Most colleges prohibit alcohol on campus at all. And it's not just a matter of underage drinking, which some people make the mistake of thinking. In most cases today, no one, not even faculty members in most cases, are allowed to have alcohol on campus, except in very controlled circumstances, a social event or something like that. Also, under student conduct violations are things like physical altercations or threats, fights, harassment or bullying. And that's always a difficult one to navigate because, again, the definitions of that can be kind of hard to parse sometimes. Property damage or vandalism, and violating housing policies on campuses. Going back to the top of the list, probably the most common reason we see that people get expelled from housing is because of having alcohol in their room. And again, some schools are very, very strict about that. Then lastly, Title IX concerns. Title IX violations are really a category of student misconduct, but they involve federal law and regulations, and so they go beyond the school's policies. Title IX is part of federal civil rights law, so it has a very structured process that has to be followed. The law overall is about sex discrimination, but for the purposes of what we're talking about here, it usually means accusations of sexual harassment or even sexual assault. Under that umbrella, we have, sexual harassment. Again, the language that the school is typically using includes things like non-consensual sexual conduct or outright sexual assault, stalking or relationship violence, or quid pro quo situations involving a power imbalance, for instance, between a faculty member and a student, or a higher ranking faculty member and a lower ranking faculty member in some cases. And also retaliation falls under Title IX prohibitions. If somebody files a Title IX issue, or file a Title IX complaint, any retaliatory behavior they might receive because of that Title IX filing is considered to be a Title IX violation too. In its most serious form, Title IX can also involve criminal charges. So it's exceptionally important to act very carefully from the beginning if you're looking at an accusation like that. At KAL, we don't handle criminal charges, but if you do have to get a defense attorney, we're able to work with them in a way that protects your academic rights with the school, while other aspects of the case are dealt with.
Dr. Wright, something you shared about plagiarism made me think of something that I would love to get your thoughts on for our audience. Specifically, in your experience, what is the outer limit of plagiarism? Specifically, one thing that I have personally encountered is clients not understanding that, even using things like Grammarly to substantively restructure or even like word substitution and grammar rewrites can amount to plagiarism and unauthorized use of assistance. And I was just curious if you could touch on that piece, because I think sometimes people don't even realize that.
Yeah, that's a very good question. And because AI and things like, Grammarly and ChatGPT and the way they're being used now are new. So the rules around that are still being developed. And that varies a lot from one school to another. But you do have to be careful and realize, as kind of the definition of plagiarism has grown as we've gone through this, plagiarizing now doesn't just mean copying some other person. Or getting some other person to do something for you, right? If you're using an AI platform that's just generating content for you, that in and of itself isn't good enough to pass as your own work. So a school is going to consider that plagiarism. You have to be very careful to always parse the syllabus of the class you're in, because some classes now are really encouraging people to use AI because it is such a valuable tool and it's something you have to learn, but that can make it even more difficult to know exactly where the boundaries are. Things like Grammarly and ChatGPT and other AI platforms are great for organizing things, and for pulling up ideas and things like that. But always be aware that when you submit work, be it a paper or an exam or whatever it is, it really has to be a product of your own. You have to take that information and then craft it in your own way. You can't just basically cut and paste, what AI turns out for you, right? And it's dicey. It can be very tricky, and that is part of kind of the new frontier of this that we're confronting all the time. And at this point, all you can do is just err on the side of caution, and always make sure if you aren't sure, when you're pulling something up, then change it. Make the concept your own. If it's coming from some other source at all, make sure to just cite that source and cite it properly. Just be on the careful side whenever you can be.
Absolutely. As we move forward, we're going to talk from the types of allegations to the potential consequences. And much like the types of allegations can go from minor, potentially getting a zero, cheating on an exam isn't necessarily minor, but it's not to the level of a sexual assault in those kind of categories. The potential consequences go higher the more serious the conduct. So academic integrity consequences usually relate to something like a zero on the exam that you were alleged to have cheated on, or a zero for the assignment that you allegedly cheated on or plagiarized. Those things can add up, though, as some colleges and universities have what they call building consequences. So you might have a minor consequence for a first offense, but if you have a second offense of cheating or plagiarism, your consequence may be more serious. Then they go into things like not being able to participate in certain academic activities. So some schools have policies in place where if you have an academic integrity violation on your transcript or noted in your student record, you may not be able to participate in study abroad activities, for example. And then there's always the possibility of a notation being put on your transcript. So if you have an academic dismissal or an academic notation, an integrity notation on your transcript, that is on your transcript for either a period of time, and it could be seen by potential transfer institutions or graduate schools that you may apply to later on. The more serious consequences are suspension and expulsion, obviously expulsion being the most serious. Suspension, you may be asked to leave campus for a period of time and may be allowed back in, or your student would be able to be let back in shortly after serving a semester off or what have you. Sometimes those do have possible things that you need to do to be reinstated. You may need to reapply. You may need to have a meeting with the campus community rights office to ensure you're doing things that you're supposed to, or your students doing things that they're supposed to. Permanent expulsion would be that your student would be removed completely from the campus and have that notation on their transcript. All of those, are things that you have to consider when those things happen, but they're also things that you can get support as you and your child maybe go through any of those types of situations. And we're going to turn over to what happens in the first 2 hours. The student gets their allegation, and now what?
Right. And so, the first 72 hours are very crucial, and they're crucial for a lot of reasons. And I think the natural instinct for parents when they hear that their child is in jeopardy and in a sticky situation is to want to react, because you're parents and that's what that's what your gut is telling you to do. But oftentimes that's the wrong move. And the reason for that is because you can react too quickly. In those first 72 hours, you probably don't have all the information you need to appropriately respond to the situation. And by reacting too early without all that information, you set the tone prematurely for how the matter is going to be handled. And the other piece of this too is, while it's certainly helpful sometimes for parents to get involved, your child is now being treated as an adult in the higher education world, and the school is really looking for it to come from them versus you. And that can be hard because perhaps you were more involved in your child's education when they were younger, but that's really important. And so, again, it's simple things that kind of you sometimes can take for granted, but pause before reacting, right? Talking with your child of, okay, what happened? What does the student handbook say the process is going to look like? What kind of information have you gotten from the school? What kind of information do we need before we can respond? And delaying your response is not any way, shape, or form lying or concealing anything. It's just making sure you have all the facts so that you can have an appropriate response when it is required. Sometimes it makes sense to respond within those 72 hours to request preservation of certain types of information. So say that your child was accused of doing something that was captured on film, or your child has reason to believe that they would have been captured on film. We always like to advise that you request that early because of the fact that sometimes schools will record over their footage because that's just what some schools do. And so if you ask to preserve it and request access to it, that puts you in good standing. Now, schools can push back on your request to access footage, but the key word is preserving it as well, because they have to preserve it while they resolve any disputes regarding access to it. And also, it's not a bad idea to ask your child and even yourself to write down what you believe happened so that you have that fresh in your mind when it's early on, because as time goes on, memory gets harder. And also, it's not uncommon for you to hear from your child that the school is taking some interim measures. So those could look like, in a Title IX context or in a student conduct context, maybe no contact orders. Those are usually both ways, meaning they'll apply to both your child as well as the alleged victim of the alleged conduct. And other ones can include things like class restrictions, sometimes housing changes, and they are common and they don't within themselves imply guilt. Now, when it's a Title IX situation, there is a requirement that schools do not impose punitive actions against the respondent, and a respondent is the person who's responding to allegations of Title IX. And so you have to be careful and mindful of those types of actions that the school does early on, because sometimes they can be punitive. So generally speaking, no contact orders, those are usually okay. But if you get to a situation where it's preventing your child from accessing their education, and it's punitive in nature, such as they're not allowed to go to class or things like that, that might not be appropriate, right? And so that's important to just kind of keep on your radar. And the other thing that's really important to understand about both academic integrity, student conduct, and Title IX, that oftentimes the first outreach the school is going to have with your child, because they're not going to necessarily have it with you, it's going to be through your child, is usually a meeting request versus an expectation for a full explanation. So oftentimes what we'll see is schools will have a professor meeting or a faculty meeting with a student when they're accused of academic integrity or student misconduct. And the reason for that is to see if it even needs to go further, because a lot of times schools will have policies where there can be an informal conversation, so to speak, and only after that will the faculty or the professor decide whether or not they're going to refer it further to academic integrity or student misconduct. And so while you have to be careful of those meetings, it's important to go in there and be informed and be cautious of just how much you say. They certainly are not uncommon.
And Attorney Garcia, when you were talking about that, it made me think of several students I worked with student conduct. One of the things I always told them to do is, as you prepare for that initial meeting, not that you're using it to use in that meeting, but write down the raw instance of what happened. Who was there? What was said? Who said what? When did they say it? And you find sometimes, particularly in student conduct areas, that the other people that are in the room might be able to act as a witness for what happened when it comes to that more formal meeting. And if you wait too long, you might have forgot that Jerry was at that event as well. So it made me think of those kinds of meetings with students.
I had a question too, or to get your reaction, Attorney Garcia. I think it's kind of natural for parents in K through 12 situations, because in that case it's usually a school, it's local, it's people they know. The other kids are in the school, they might even know some of the teachers or principals or things. And when they get an initial complaint, the impulse, right, is, oh, well, I can just call so-and-so. Let me just call the school and talk to Mr. So-and-so. That's, little Johnny's teacher. I'm sure we can straighten all this out, and just, kind of jump in there like that. My sense is that's a perilous thing to do, right? Can you speak to that a little bit?
Yes, and I think that goes back to the point that I made earlier of the expectation when you're at higher education is, if you're not already legally an adult, you're being treated as, an independent individual outside of your parents. And so oftentimes, while good and well-intended of a parent's urge to want to reach out and get involved, it gives the appearance that your child can't handle the situation on their own. And it also gives the appearance that this situation is serious enough that you feel the need to get involved, which can undercut any future argument that this is really just a misunderstanding and shouldn't be on the school's radar. And oftentimes, because you're removed from the situation, you're going to be acting more on emotions than facts. And I don't say that in an ill way, because again, you're doing what's in what you believe is in your child's best interest. But because it's so emotionally charged and whatnot, it's just, schools aren't used to that. It's not appropriate, I would say, in those settings, because they're expecting it to come from the student themselves. And in many cases, I don't think it's unheard of for the school just to refuse to engage with the parent, because they're maintaining that stance of, this is really a matter between your child, the student and us, and not you, parent.
Well, in Attorney Garcia, there's always the FERPA regulations where colleges really aren't allowed to share those things for the student's record, particularly in the academic sense. They're really not allowed to do that. I've been in many a phone call with a parent saying, "But I pay the bill," and while I do understand that you're not the one taking the class and it's not your grade that I'm sharing, it's your student's grade and it's their property.
Correct. If your student is under 18, that's slightly different, but presuming they're over 18, to Ms. Miller's point, they're not going to talk to you, and they shouldn't, absent having a signed FERPA, because if they do, they're opening themselves up for a possible FERPA complaint.
Absolutely. Absolutely. And as we move forward, we'll talk about why silence matters.
Right. And so building off of some of the previous statements that I made with respects to just how you want to be mindful of what you do and do not say, again, it's really important to understand that the school is going to be looking at everything, including what you say after the allegations and including after you're put on notice of the allegations. And so it's really important to understand all of the information. I think sometimes what we see a lot from students is they are inclined to say, I didn't do it, when in fact that they have done it. And it is very hard to get your credibility back once you've lost it. And so a better response is to defer and say, I don't recall, I need time, I appreciate this information, and delay it so that you have the ability to reflect on what you're being accused of doing, what your rights are, what the process looks like, and then come up with a game plan going forward. And so assuming that the school spoke to a parent with or without a FERPA, they're going to think about what you said too in rendering any kind of decision related to the allegation. So what you say can also be taken into consideration and perhaps negatively used against your child. And so it's not just what your student says that matters, but it's also what you say that matters. And even if you're not directly communicating with the school, it's important to make sure that you're not telling your child to say something that might put them in hot waters later on. And again, just really advising them and suggesting to them, let's pause and get a better understanding of the situation before reacting. The other thing too is, you don't want to incidentally admit to doing something that you actually didn't do, or in cases where schools are not following the procedures that they should be following, you're, by engaging with them, having it later be construed that you waived any disagreement with the fact that they're not following their processes and procedures. So for example, sometimes schools will not have advisors or inform students of the right to have an advisor present for a long, term suspension or expulsion in a public school setting. And that can run afoul to the due process clause, right? Because it's important for students to have a meaningful opportunity to be heard. And part of that relates to having an advisor there. And so by going forward to that meeting without the advisor being there, the school could come back and say, well, you didn't ask for one, you didn't challenge it. And so again, it's just really important to pause and allow time to strategize. They also move really quickly. Schools, the process moves really quickly. So making sure that the school is following the procedures and that you're not kind of getting overwhelmed, which is very easy to have happen in these situations, is incredibly important. And pausing and knowing when to bring in information and support from outsiders. So, what type of sanctions is your child facing? Okay, are they pretty severe? Are the facts not great? Because again, you need to think objectively in these situations versus from an emotional standpoint, and know that schools only have to follow the preponderance of the evidence standard, which is 50% in a feather that someone did it. And so you need to be able to look objectively and say, okay, well, could someone conclude that my child did it? And if they did, it might make sense to reach out to a group like ours to get that kind of support and guidance. And again, even when maybe you think that it's a strong case, but the sanctions that your child are facing are pretty extreme, schools have a lot of discretion. We see them use it not in the right ways. And that's where, having someone who has experience in advocating for schools to use discretion correctly is incredibly important.
Absolutely. And it was a good note that you mentioned about supports, because my next slide talks about what supports are available within schools. So your student may come to you and say, I have this allegation and I don't feel like I can get any help, and they feel lost and don't know what to do. You can help them understand what supports there are available in the schools to help them with this. One important thing to remember, though, is these supports, as they're provided by the schools, will help your student through the process. They're not going to give them defense, and they're not going to help them defend themselves with this. They're going to provide them guidance to work through that process, but it's coming again from the school's perspective. So academic dishonesty, there's faculty hours. So maybe it's a informal conversation with your student and the faculty member that they believe that they used AI when they weren't supposed to in a paper, or they believe that they cheated on an exam because their exam and the person next to them, the exam looks very similar. But they can meet informally with the faculty. Then a lot of schools will have an academic integrity office or coordinator whose job is to kind of oversee these types of things. Student success coordinators or student advisors are also a good resource for your students to have, especially with academic issues. Not all schools have an ombuds office, but most schools do have a disability services office who can also help with those things if for some reason maybe the allegation of academic misconduct stems from something that the student has disability related. So maybe your student has accommodations due to a disability, and you can involve the disability services office, or they can go to the disability services office to help them with that. Student conduct violations usually fall under the order of the Dean of Students or Student Conduct Office or the Student Residential Life Office. A lot of schools will have a counseling center that helps with that. And some schools, depending on their size and whether they're private or public, may have a student legal services office. Again, these people are going to be there to help them with the process of navigating this this hearing procedure or what have you. They're not there to provide them advocacy in the sense that someone like our offices would be able to provide advocacy. Obviously, with Title IX concerns, all schools have a Title IX coordinator. Some have a designated office for those types of things. But in addition to that, because of the types of allegations that fall under Title IX, counseling services are always available at schools and usually provided and listed as some of those interim measures that we spoke about in the earlier slide when they're going through these processes. So as parents, what you can do is you can help your student understand that those services or those offices and support are available in the school, and you can help them maybe navigate the system to go through and reach out for those services as appropriate, because students do, again, have to reach out to those. They're not going to come and offer them to them. The student has to ask for these support services.
Thank you. So now we're going to move on to when to involve advocacy. And that's what we really do. And so it's really important as parents to, when you're sitting down talking to your child, looking at the emails or any documentation they receive, look and see what's being said. It's really a good idea to have an advocate stand with your child when the potential sanctions would be suspension, expulsion. If you get notification that if a student is found responsible, that it's going to be placed on their transcripts. When students are asked to write a written statement or to just go to an interview with an investigator or a dean, anything like that is it's always a good idea to think about getting an advocate so an advocate can walk through the process with the student. Of course, if it's Title IX, a Title IX, and your child is being accused of a conduct that's inappropriate, and you get that your child is being looked at as the respondent, the person that needs to respond to the complaint. Other things that we see, when parents feel like the school is being biased, or there's a conflict of interest, or you reread the student handbook and you know that the school is not following their own policies and procedures. Again, it's definitely a time to consider reaching out to someone like us to help your child through the situation. Now, Rob, what do parents often do wrong at the start?
Well, it kind of dovetailing into what we've just talked about and going back over those points again, kind of one of the first things the parents want to make sure they do is just don't act too quickly. You don't have to respond right away. It's not a 911 situation. It's important, but it's not an emergency. Ideally, you would contact an advocate, right? Of course, that's what we would advise you to do. And if you do that, we would say don't communicate with the school directly. Let your advocate go ahead and communicate with the school. If not, or if they say, they want a response right away or something like that, or they want you to respond right away, it's perfectly fine to do that by just saying that you've received their message and you will be responding once you've had a chance to, review what's going on and kind of check into this yourself. You don't have to just, come up with something really quickly and talk to them immediately. Everything doesn't move according to their schedule, right? You have a right to participate in this in an informed way. And by no matter what you do, don't assume that the school is going to proceed with this notion of fairness and neutrality. Even if the school maybe intends to, that's not always what happens. The people at the school have their own interests. They have their own idea of what happened. And, yeah, sure, we would hope they always do the right thing and they proceed fairly, but don't assume that. And don't, assume goodwill. Just take everything, with a grain of salt. And again, ideally, talk to somebody, reach out to an advocate, someone like us, at least initially, to get an idea of what you should do. And then another thing is, don't allow unprepared statements. In a K through 12 case, the people at the school really shouldn't be questioning your student without you being present. Now, that's ideal. That's not what always happens. But certainly in any case where you're looking at potentially serious consequences, the parent should be there, and you have a right to insist that you be there when they're talking to your child. And certainly if you're a college student or an adult student yourself, don't put anything in writing. Don't, admit to anything. Don't discuss anything that you aren't prepared for. And one of the things we always say is whenever you're asked a question that you're not comfortable with or don't know the answer to, it's perfectly fine to say I don't know, or to even say, in some cases, well, that's not something I'm going to go into. I'm not going to talk about that until I've had a chance to kind of weigh all this stuff myself and see what's going on. Just don't be rushed through things and into doing things that might hurt you in the long run. But I think that pretty much is what, the most common mistakes, I guess, that we see that parents will do, in just kind of a rush to want to just kind of throw a blanket on the fire, right? And just put this out, oh, we can take care of this quickly, right? That's probably not true. And you have to realize that, you have to protect your interests and your child's interests, in every way you can going through this.
Absolutely, Rob. And actually, we're going to step a little bit more into what some of those actual common missteps are that parents do. So,
Thank you. Thank you. I think Rob really went over most of them. rushing to explain their side of the story before knowing the policy, really even knowing what the child is being accused of. When parents contact the school directly, especially at the college level, you really want to make sure you have an advocate or that student contacting the school after speaking with an advocate. You don't want to just treat the situation as just a misunderstanding. You have to take each allegation seriously, as Rob said. And Rob talked about student statements. You know, in the K through 12, the school system, you know, the administrators, they are real quick to get students to write a statement before even notifying the parent. But and you know, one of the things that we see often in the work that we do, parents wait too long to get help. They,
Mhm.
you know, parents go at it to help support their child and not understanding at the level that an advocate would understand. And then after an appeal was denied, after a second appeal is denied, then we get called upon to challenge the process or to file the last appeal. So those are some of the things that you know, to build off of what Rob was saying that parents do wrong. But Attorney Garcia, what should parents do instead?
Right. So we're going to say it again. Pause, breathe, take it, take a walk with the dog, just reset and then assess. Okay. Once you've gotten in a good headspace, um, you know, don't respond immediately. That, just building off what my colleague said, biggest mistake of just impulsive responses. Don't do that. You need to understand the allegation, right? And how do you understand it? Okay, so what do you need to understand it? That's critical thinking of, do you need to review the student handbook? Do you need more materials from the school? Because if that's what you need, then that should be documented and documented in writing, right? But do that and keep it limited to what the request is. Don't use it as an opportunity to just start talking about different things. Keep it to the point. Preserve evidence early. So screenshots, texts, drafts, timestamps, anything that someone might delete or try to get rid of. And again, going back to what my colleagues have shared and I myself shared, if your child called you immediately after the allegation, write down what you recall that they did and keep that to you for yourself personally, and encourage your child to also write down their summary of what happened. And if there were any witnesses there, ask them. And I say ask them when you know that the school is doing something. If you know the school is not doing something, you haven't gotten any notice or reason to believe that they're going to be bringing allegations against your child, it doesn't make sense to try to start something that's not actually happening. But if you know that allegations are happening and there were witnesses, it could make sense to reach out and ask for them to write down what they recollect, so that should that information be needed in the future, you have it closer to the time when they first spoke. Prepare before you give any statement. So as Dr. Wright said, don't do any unprepared statements, right? You want to be purposeful about what you share with the school. No interviews or written responses without guidance, and guidance from either individuals like ourselves or, from any materials that you might find on the school's website. And again, early involvement is always best. So oftentimes the cases that have the greater chances of success are those that came to us when, I'd say, like in their infancy, where they got allegations, the notice of it, and even before that preliminary meeting, they reached out to us and we gave them advice, and we were able to make the matter resolve pretty quickly. When you decide to get help later on, the options that we can employ are limited, right? Just by virtue of what processes are in place. And also, we have no control over the narrative because you've already started it. And so we're more playing offense versus defense. And that's really important in these situations, you want to be proactive, not reactive. And so getting involved and getting support early is really crucial in the likelihood of success. And, with schools, you've already put in so much time, energy, and financial investment in your child's education that you have to understand that if the outcomes aren't great in whatever allegation they've received, it's going to have severe impacts on their success within the university as well as any other higher, continuing ed or employment, depending on the nature of what these allegations are. Like, for example, medical school. If you're dismissed from medical school, that can be career ending. And I know Ms. Miller can talk to that. And so it's just, there's a lot at stake here. It's different than the K through 12 level. They don't have to have you come back, right? There's no
Exactly.
obligation to keep educating you.
Exactly. I always think of this as the best way parents can help is they can be like the project manager, if you will, in these situations. Help the student organize their documents, help them figure out how to save those documents, help them prepare those statements, because students aren't likely to have had those kind of conversations with, what they feel as an administrator who might be, I can imagine when I was in grade school sitting in the principal's office, right? If the dean comes to me, it's like going back to the principal's office all over again. And you can help your student, grow and learn how to handle those more adult conversations as that project manager, kind of helping them organize this process without stepping in and taking over for them. You can, while it's a difficult situation, it can also be a very strong learning opportunity.
So true.
So I think we're going to talk about a few examples, unless you had something else, Dr. Stewart.
No, I was ready for the examples. Attorney Garcia really set everything up, because the first one is the early email. So, we're not using any actual names, of course. But I remember one time I had a client where the student had received an email and was being accused of cheating. And before the parent could really talk to the child, the parent emailed the teacher, the professor. And it just blew up, because not only was it was an allegation, and the relationship was between the professor and the student, but the communication was unprofessional. And so that goes back to what Attorney Garcia was talking about stabilizing, pausing. And I know my colleagues, we've had parents that email the school and make the situation worse.
Mhm.
Yeah.
Yeah.
And it's difficult, right? It's difficult to hold.
It is. And on a side note, like then the school not only has to deal with the student, but then they now have to deal with this parent, which is not something that they usually the school's willing to do. So now you've already made something that could be a very quick conversation turn something that could end up being more adversarial.
Yeah. That's true. Now, in the second case study, the second example, an unprepared interview. One of the reasons why, parents and students come to us is because we know how to really work with the school, understand their school policies, and we know to understand the expectations as an advisor and a student. So for this one, we had a parent who decided before they retained us that they were going to be the advocate. And so they had planned to go to this hearing. Their child was accused of something. They were going to go to the hearing and they were going to speak for their child. Yeah, why? My colleagues know that didn't work out too well. Why?
Well, for one, again, because they're a college, this is a student-focused thing. They want to hear things coming from the student voice. So a lot of those hearing situations, the advisor's role is there to be supportive, not give evidence or anything of the like. They're there to support the accused, the student. In our role, we're very good at that, and we know that we're not supposed to say anything, but we can and do very often have conversations and help prep that student for that interview so that they understand what questions might be coming of them. That's one of the things that we do is we give them possible potential questions the committee is going to ask them and some reasonable responses so that they can answer those questions in an informed way and not try to answer it off the cuff and try to think of things on the fly. Doing that never goes well.
That is so true. Thank you. And lastly, waiting too long. We find sometimes, we recognize sometimes the students tell the parents really late, but then the parents either try to handle it themselves or, it's a big issue, big decision, and they reach out to us at the last hour. So I leave you with this. If you are watching this and it is Friday at 6 p.m. or Saturday or Sunday, and your child has a hearing Monday morning, you can go to our website, pick up the phone, and somebody will answer or send us a message and we will follow up with you. But at the same time, when you're in a situation like this, try to give yourself some time to really be able to process, get an advocate. So waiting too long is not the greatest. Not at all. It's not a great idea.
And it's part of being cognizant of those due dates. Like, so, when you have those hearings or even the appeals after those hearings, there's usually a timeline or a deadline, 5 business days, 10 business days, something of the like. You need to be cognizant of that and not wait to seek help for that on, the 9th day at the 11th hour.
And we do get those phone calls and we work with the clients. They're speaking to Attorney Garcia on a Friday at 6 p.m. Eastern Standard Time, and they have a dismissal, a hearing on Monday at 9 a.m. Eastern Standard Time, so, yep. But thank you for that. Those are some just examples of things that we deal with day in and day out. Now, Rob, key takeaways?
Key takeaways. Allegations come in, different shapes and sizes, and there's a huge variety, a whole spectrum of different kinds of allegations and types of misconduct you can be accused of. And they all can be serious, but they all need to be addressed in different ways. And then timing and silence, in other words, controlling when you respond and when you don't respond, are really key tools. They can be very, very key parts of the strategy that you want to do. And of course, all through this, we've emphasized the idea of just kind of going off half-cocked, right? And just responding. And I would add too, at that point, when you're first responding to things, another thing you need to be careful of if you're your move to respond to them is not to get emotional and angry yourself. That's another reason why you don't want to respond too quickly. Especially if it's, a K-12, it's your child, there's a natural tendency to take it personally and, and remember, in a lot of these cases, probably most of these cases, there's all kinds of arguments you can have about the formal rules and this kind of thing. And that's what we're there for. But you also have to remember that what we're usually asking for is for these decision makers to exercise their discretion in our favor, right? We want them to just settle this, right, as minimally as possible, right? And so the more you don't go in, and I think one of the worst things people can do, and it's natural to behave this way in a defensive posture, is to start making accusations at them. Well, you guys did this and you guys did that, right? That might be true. And those might be issues that down the line, as you go through the process, you might bring up. But that's never a good way to start, right? The good way to start is to say, okay, we're going to hear what you have to say. We're going to digest that, and we're going to respond to that in the way that's best for us to respond to that. right? And for that, that's why we might say, you know, legal advocacy might become essential. We always recommend it, but it could become essential at some points. The students aren't alone. You know, there are resources like we've mentioned, and obviously there are organizations like us that are there to help. And as parents, you really do play a key role. You can help or you can hinder. And I know your intention will always be to help, right? But we can help you figure out how the best way to do that is. And you know, go with the better angels of your nature instead of what I know these kind of situations often you know, make people want to respond in a defensive way. It's completely understandable, but you know, that's what we're there for, to kind of calm things down and respond in the best way for you, the best way to get the best result for your student.
Well, thank you so much, Rob. Greatly appreciate everyone's participation today. We don't have any questions, but as we move forward in closing, we just want to thank everyone for coming. We're honored to do the work that we do, and we're honored to work with all of our clients, and even looking, you know, unfortunately, you know, things happen, and, you know, but when something happens, we are here to support your student, no matter if they're in K through 12, college, or university. Our contact information is on the screen. And then if what you heard today resonates with you and you really greatly appreciate us sharing this information with you, we ask that you scan the QR code and share your feedback with a Google review. We appreciate the positive review. We appreciate any suggested topics you would like to hear more about. We do have a podcast. And when you go to kaltmanlaw.com, you can hear more about our podcast. So again, Ms. Miller, Dr. Wright, Attorney Garcia, thank you so much for being here this evening. Very important conversation to help our parents understand what could happen and how to respond.
Absolutely. Thank you for coming.
Thank you.
Thank you.
Done. Event ended.